Welcome back. This lecture will be on civil liberties. Please have read the chapter 5 before starting this lecture. We will be talking about the rise in civil liberties, the right to privacy, freedom of religion, right to free speech, the right to bear arms, the right of the accused, and then at the end we will discuss the difficulty between balancing fighting terrorism and protecting our civil liberties. First, let's kind of distinguish between civil rights and civil liberties. So, the civil rights and civil liberties are both talking about our rights, but they demand opposite things from the government. Civil rights requires government action to help secure individual rights. And we'll be talking about that in the next lecture. Civil liberties restricts government action to protect individual rights. When governments enforce civil rights for some people, they often limit the liberty of others. So, our battle for civil rights has led to more robust civil liberties for everyone. It's a difficult concept, but after reading the chapter and listening to this lecture, hopefully you'll have a little better understanding, this lecture and the next one. So, individual protections are always balanced by community needs and by other people's rights. And this is the great trade off. We have majority rules versus individual liberties. So, it's the two sides to rights. In a democratic republic, that means that the majority should get its way, but we are a nation of rugged individuals and we tend to tilt more toward protecting individual freedoms and rights. So, civil liberties are limits we put on the government so that individuals can exercise their personal freedoms. So we we added the Bill of Rights, amended the Constitution to add the 10 Bill of Rights to our Constitution only a couple years after the Constitution was ratified. Um, And then it took another 70 years or so for us to pass the 14th Amendment after the Civil War. And the 14th Amendment states that no state shall deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So, what the 14th Amendment was addressing was that even though we had the Bill of Rights in the federal Constitution, as we learned in the federalism lecture earlier, states have the right to make their own laws as well. And so many states, not necessarily Nevada, because we had our Bill of Rights, our Declaration of Rights, right at the top of our Constitution, but some states maybe didn't want the same type of rights. So uh, many states weren't applying the rights that were in the Constitution on the state level. So Congress felt that we needed an amendment to the Constitution that said no state shall deprive anyone of these liberties. We've already amended the Constitution, the federal Constitution, to say that people have freedom of speech, freedom to own guns, freedom, protection of the accused. All these rights should apply to everyone, and no state can keep that from other people. So, had that amendment just been passed and everybody went along with it, that would have been great, but that was not what happened. And your book talks about a process called selective incorporation. And this is something that has happened over many, many years where the Supreme Court is brought a case that shows that a state or an entity of the state is withholding the rights of someone that is against the federal Constitution. And the Supreme Court has to rule on that. And when they rule on it and they turn to the 14th Amendment and say, hey, states, you're not allowed to deprive any person of life, liberty, and property. And this is a case where your laws are doing that. then one by one in these court cases, the Bill of Rights is incorporated into all state governments. So you need to know this definition of selective incorporation, which is extending the protection of the Bill of Rights to state governments one right at a time. States continue to make Jim Crow laws where even though um, black males were allowed to vote after the 15th Amendment, uh, there were many states that still made some kind of regulations with which withheld their right to vote, and these laws had to be addressed only through the courts. So, in time, the court incorporated almost every part of the Bill of Rights, beginning with freedom of speech in 1925, and then ending with the most recent, the right to bear arms in 2010. So let's look at the list of these are all of the rights that you can find in the Bill of Rights. So um, the First Amendment gives us the right to freedom of religion. Two parts of it: free to exercise our religion, and free from the establishment. The government cannot establish a religion. We also have freedom of press, freedom of speech, the right to peacefully assemble, and the right to petition the government. All that is in the First Amendment. And each one of them had a different case that once it made it to the Supreme Court, and the Supreme Court said, hey, in this state, like this one was in Minnesota, you're not allowed to infringe upon the right to free press. Then it incorporated the Bill of Rights. Once the Supreme Court judges on it, it means that all states, that applies to all states. So from this point on, if any other state tried to infringe the right of free press, the courts would look to this Supreme Court case and say, no, 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 it's very clear now. It's almost like a parent giving the instructions, and then each child's like trying to, find a different way to get the candy or get what they want. Um, and these Supreme Court rulings hopefully were the way to incorporate all the Bill of Rights so that states could not make different laws that infringe upon people's rights. So the most recent one was right to bear arms in 2010, where the court finally did say, yes, this doesn't mean just to um, arm a militia, but it also means that individuals get the right to bear arms. There are a few that weren't incorporated, like where's the no quartering of soldiers? Nobody's really brought a court case. I think that it's kind of a given. Nobody has had any state has thus far made people quarter soldiers, house soldiers. So that case didn't come up, and there are a few others. But this is called selective incorporation. So if you can read on this and make sure you understand this meaning, there will be a question on the exam. Make sure you understand what selective incorporation means. Okay, so then there's the right to privacy. Now, if you go through the first 10 amendments, the Bill of Rights, you will not see the words right to privacy in there. Matter of fact, you won't find it anywhere in the Constitution. But there was a court case in 1965, Griswold v. Connecticut, and the question that they brought to the court was, is contraception a private concern or a government concern? Does the state of Connecticut have a say in whether a person uses contraception or not? And so the judges at the time found the right to privacy in the essence of the Constitution. The Supreme Court justices said there are penumbras or shadows and emanations that derive from. So they basically looked to a variety of places, but specifically the First Amendment, the Third Amendment, the Fourth Amendment, Fifth, and Ninth Amendment, and said, so for example, in the First Amendment, you have the right to freedom of religion. So that the essence of that is that The government can't come in and tell you how to think or pray or assemble, or your thoughts about God, or about how you, or whether you believe in a God or not believe in God. The courts can't come in and force that on you. Also, the way you speak, freedom of speech. The Third Amendment is the quartering of soldiers. So they said, well, if the framers felt that you didn't have to have people come into your home, especially soldiers, or government can't bring people into your home, then they must have thought that your home was a zone of privacy, just like your conscience was a zone of privacy for your belief in religion, or um, no belief in religion. Fourth and Fifth Amendment, all the rights to the accused. Those are rights to um, privacy, that you have a zone where you don't have to incriminate yourself, where you get to have a lawyer. And then the Ninth Amendment, we haven't gone over this yet, but the Ninth Amendment says that there may be other rights that we have not spelled out in these Bill of Rights. And it just because it's not in here doesn't mean it doesn't exist. So the court, when they reviewed this case, they said there are shadows um, uh, of the First Amendment that creates a zone of privacy. And we feel like these flow from other amendments, particularly the Third Amendment, were designed to protect privacy. And the Ninth Amendment declares that other rights exist besides the ones we have mentioned, and these are retained by the people. So the court ruled in favor of the contraception case and basically said the government didn't have a right because of our right to privacy, or at least the essence of the right. So then, when the court case Roe v. Wade, which I'm assuming everybody has heard of, this was struck down a Texas law banning abortion. They brought it to the Supreme Court. They brought this case to the Supreme Court, and the Supreme Court looked to the right to privacy and said, yeah, a woman has this, the right to privacy includes a woman's right to make her decision of what to do with regarding an abortion and regarding anything in her body. So so that was in 1970. Oh, I don't have the date here. Late 70s, I believe. Mid to late 70s. And since then, there have been many, many challenges to this issue. Many states have tried different types of laws, like banning federal funding, banning abortions in public hospitals, any hospitals that are run by government, making regulations for waiting periods for women, making parental consent for anyone under 18. So all kinds of different laws, making the limit of when you can have an abortion shorter and shorter. If you go to this link here, this is the most recent. Um, when an abortion is allowed, state by state, this link, you can go and you can hover over the state. So they'll ask the question, does the state restrict abortion after a specific point in pregnancy? In Nevada, it's yes, and it's 24 weeks post fertilization. So you have different fetal viability, post different terminology of when an abortion is allowed. And then you also have many states that have that are banning abortion now, and we will probably see, maybe even within this class time, some cases that are brought up challenging Roe v. Wade, and there is some thought that this current makeup of the Supreme Court may overturn Roe v. Wade. So we'll see what happens there. Okay, then do I need to go over? Yeah, so there was one of the cases was Planned Parenthood v. Casey, where the vote was really split 5-4, and said that states can legislate measures to ensure contemplation. So they can put regulations in place to make a woman, like maybe have the woman watch a video or wait a longer period of time before making the decision, or go and see other options, adopting and so forth. Okay, so then moving from that on to sexuality between consenting adults. In 1986, the Supreme Court heard a case where they actually upheld Georgia's anti sodomy law. So they ruled that the right to privacy did not extend to same sex couples. And then, how many years later? For 17 years later, a different Supreme Court, a few members were different, reversed itself in this Lawrence versus Texas, and finally extended the right to privacy to same sex couples. So there was a period of time where the court ruled that same sex couples did not have the same rights as other people. And finally, the court said, that's ridiculous. Of course they do. And in their ruling, they said liberty protects the person from unwanted government intrusion into private places. The First Amendment gives us a freedom of religion in two succinct commands regulating religion. The first one is that Congress shall make no law respecting an establishment of religion. That's called the Establishment Clause. The federal government may not establish an official religion. So you need to know that this is the Establishment Clause. The second part of it is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And it may not interfere with the religious practice. That is the Free Exercise Clause. And of course, there are limitations. If religions are killing people, there is some right for the government to intrude. But we're talking about the free exercise of religion that doesn't harm people. So the Establishment Clause, Americans were practicing many faiths at the time of the Constitution. The Constitution posed a threat. What if the federal government imposed a national religion? And so this keeps government officials from favoring one religion over another, or religion over non-religion. So we do have practices of culture, religious culture in government, but the government is not allowed to establish a national religion that everyone must follow. Freedom of speech is also in the First Amendment. It's crucial to democracy, and the court gives this a very preferred position. If freedom of speech conflicts with another right, the court will generally prefer to protect freedom of speech. Democracy requires a rigorous debate. Hate speech is also protected. Hostile statements based on someone's personal characteristics, such as race, ethnicity, religion, and sexual orientation. And speech has had some limitations. It's gone through different periods, but the one I'd like you to remember is that if there was a period of time where if speech presented clear and present danger, then the court doctrined that this permits restriction on free speech if the officials believe that the speech will lead to prohibited actions such as violence or terrorism. It was difficult to curtail because, once the speech is out and the violence has started, it's hard to stop it before it happens. But if you have a question on your exam asking which freedom is clear and present danger test talking about, it would be the freedom of speech. Symbolic speech is an expression, an act, rather than actual speech itself, which demonstrates a point of view, and this is also protected within limits. So symbolic speech can be a MAGA hat, a t-shirt, a campaign t-shirt. It could be taking a knee before a football game. It could be burning a flag. So it's protected if not threatening or intimidating. So it can be a statement of ideology or group solidarity. So if someone is burning a cross, that could be acceptable if used as a statement of ideology, believe it or not. But if someone is burning a cross that is being used to intimidate someone, say in front of um, a black person's house or nearby where someone's gathering, then that could be seen by the courts as being intimidating. In one of the court cases, this quote I think is interesting for all of us to think about, that the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. In some of the rhetoric we hear these days, you can hear this, you can see this on both sides. So just because one person finds it offensive and disagreeable might not necessarily mean that it's not protected. Fighting words, these are expressions likely to provoke violent reactions and not necessarily protected by the First Amendment. It's difficult to restrict unless it leads to criminal action. Student speech is protected. The quote is from your book that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. However, institutions have the right to make their own regulations. So some schools may make certain regulations that need to be followed. Freedom of press. Prior restraint is the legal effort to stop speech before it occurs. This is basically censorship. So the court, I don't know if many of you saw the Post, the movie The Post. That would be prior restraint, where the newspaper company found were given some classified documents. They were going to print it, and they were being asked by the government to not print it or threatened. This would be a form of censorship. The court often upholds the right to press to publish material so long as there is not a compelling national security reason. Um, Prior restraint has also arisen with the WikiLeaks case, but it's getting increasingly harder to enforce, especially with the internet, with things being on the internet. And then the freedom of press, there are limits to false things that you can say or write about someone. Anything that's written that's a lie is libel. Anything that's spoken is called slander. But you must prove the person that is being slandered or libeled against is the one that has to prove that three things: that the statement was false, that it caused some harm, and that it was made with malice and a reckless disregard for the truth. So today, courts allow even outrageous claims, cartoons, spoofs, and criticisms directed at public officials and celebrities. Um, these are still considered freedom of speech unless it is proved that it was harmful in those three categories. The right to bear arms, uniquely American, this is a unique American right. No other constitution includes the right to bear arms. The text is sometimes by some people considered to be ambiguous. This is what it actually says: a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of people to keep and bear arms shall not be infringed. So, first of all, the sentence structure seems to be a little opposite of how we speak these days, but one reading would be that it protects colonial era militias because they didn't have police forces at the time, and when the country first started, we didn't have our national military set up quite yet. So each colony was responsible for protecting themselves. So a well-regulated state militia being necessary to the security of a free state, the right for people to keep and bear arms. The other more popular reading, and the one that the courts have just ruled on in 2010, is that it actually guarantees the right to own weapons. So depending on how you view this, whether the framers meant for the time that they were in, or whether they meant for all time being and all kinds of um, future type of ammunition is okay. That depends on how you read this. The courts have basically ruled so far that we have a right to bear arms, we have a right to own weapons. However, Congress is allowed to regulate it, a well regulated militia. And so the, the, we'll talk a little bit more about this when we talk about political parties, but the conversation is often said whether the right should be or not be, when the real conversation is how much regulation should there be in light of our current circumstances with mass shootings and um, access to automatic rifles and weapons that can shoot hundreds of people within minutes. So the Supreme Court defends gun rights, and that the Second Amendment was incorporated in 2010, as we just saw a while back. This is a chart that shows that depending on the state you live in, this is for should colleges allow concealed weapons. So depending on the state, the blue states, concealed weapons are banned on campuses. The yellow states, campuses decide to ban or allow, and the green states, concealed weapons are allowed. Here's a nice, kind of humorous, funny Daily Show comedy on gun control you can watch at your leisure. Then we'll move on to the rights of the accused. So the Bill of Rights places special emphasis on protecting people accused of crimes. There's 4 amendments, 31 rights, and it's kind of a balancing act between protecting the rights of the accused and law enforcement, which is security of the general public. So the rights to the accused have expanded in the 1960s, and a lot of those rights have been incorporated around that time. But now it's tilting a little bit more towards law enforcement more than the rights of the accused. The Fourth Amendment is about search and seizure, no police search unless probable cause that a crime occurred. This is not a blanket protection. There have been some warrantless searches allowed based on the situation. This will be one of your judicial cases to look at. Mapp v. Ohio. This was a woman her house was searched. They thought she was holding a fugitive. They went in. They didn't find a fugitive, but they found some porno magazines, which apparently at that time in Ohio was illegal. And so they were able to arrest her for holding pornographic material. And she fought the case and basically said, hey, you didn't have a proper search, you didn't have a proper warrant. And so this created what is called the exclusionary rule, which means that evidence obtained in an illegal search may not be introduced in a trial. So the exclusionary rule is weakened over time. 2011, officers were permitted to break into a house without a warrant. But for the most part, the Fourth Amendment dictates that we should have a warrant before seizing our property. This chart lets you know what police do need a warrant for and what they don't in certain situations. So you might want to check that out. Then the rights to accused continuing. They have a right to a trial. The Fifth Amendment lists a whole long series of rights focused largely on criminal trials. You have a right to a grand jury that does not decide on guilt or innocence, but only whether there's enough evidence to go to trial. And then you have a right to a trial of jury 6 to 12 individuals to hear your case, weigh the evidence, and deliver a verdict. An individual is not allowed to face double jeopardy, so they can't be tried twice for the same offense. The Constitution aims to protect citizens against torture and coerced confessions. And suspects must be informed of their rights to remain silent. This isn't part of the Constitution, but it came out of a case, Miranda v. Arizona. You should know about this. Most people know this. If you start saying you have the right to remain silent, most people can read off the Miranda warnings. This is to help protect people know what their rights are. The Sixth Amendment is the right to counsel. You have a right to a speedy and public trial. In Gideon v. Wainwright in 1963, the Supreme Court ruled that the Sixth Amendment supported his right and that the state must provide a lawyer to defend those who cannot afford one. So, even though it says you have a right to a speedy trial, you also have a right to a lawyer, even if you can't afford one. And then recently in 2012, the court ruled that defendants have a constitutional right to an effective attorney during plea bargaining negotiations. So um, uh, that's in addition to just sometimes people will just get defense lawyers end up get public defenders end up getting so many cases a day, so many cases a year that sometimes they end up plea bargaining. So this is basically giving people the right to have an effective attorneys during their plea bargain negotiations. The Eighth Amendment, the death penalty. This says no cruel and unusual punishment. Cruel and unusual punishment shall not be inflicted. You can read about this in your textbook. 60% of Americans support the death penalty. 101 nations have abolished the death penalty, including all the nations of Western Europe, where it's considered a violation of human rights. The United States executed 23 people in 2017. I believe it was 25 in 2018. The book says the number of executions has been falling, as well as support for death penalty, but it actually went up a couple people. Proponents of the death penalty say that some crimes are so terrible that it's needed. It can be used to deter others. Maybe if people know that they're going to get a death sentence, that they won't do those crimes, and that it protects other prisoners and prison guards. This chart shows a map of executions in the United States. So the green states had states that executed just in the last couple of years. The yellow states had executions in the last 5 years, and the gray states haven't had any executions in the last 5 years. Nevada almost had one last year. There was a hold because there was some court cases being held up on how they were going to execute this man, and then in the interim, he ended up committing suicide. So we haven't had any, but it's not that we're not able to have executions. Terrorism, non-citizens, and civil liberties. Okay, so after the terrorist attacks of September 11th, Congress passed what's called the USA Patriot Act legislation. You should read up on this in your textbook. It was sought to enhance national security. It was passed right after the aftermath. But what it did was it actually lessened our civil liberties. It gave the government more ability to look into our private lives. So the act tried to enhance security by removing restrictions on law enforcement. Removing restrictions, however, meant limiting our rights. The Patriot Act and the broader campaign against terrorism created a new debate about balancing between civil liberties and public safety. So, do we want to be safe from terrorist attacks, or do we treasure our privacy more? That is still being debated. So, contacts with forbidden groups, rules. There's been rules that that bar Americans from offering aid to terrorists, prohibit web postings if they provide funding or other assistance to terrorist groups. The NSA is allowed to conduct international surveillance without search warrants. Many rights to non-citizens have been lessened. Most basic constitutional rights have extended to non-citizens. Procedural standard rules by immigration laws and rights have become more restricted. So, domestic surveillance requires a warrant, but to prevent terror attacks, however, the NSA has been allowed to conduct international surveillance without a warrant. Major controversy erupted in 2013 when Edward Snowden revealed the scale of this data collection. When he showed, if any of you've seen the movie Snowden, it shows how much data collection the United States has been doing on everyone in the name of national security. The NSA has collected bulk data, over 1 trillion pieces of information on phone calls, computer searches, texts, and more. I have had some people in my class, some students that have worked for the NSA, and they said that the average the NSA is not interested in what the average person talks about on their phone calls or their texts. And so I always say, if you're not hiding anything, you don't have anything to worry about. But others may have different points of view on that. So, in conclusion, it's an eternal dilemma of civil liberties and one of the most important issues facing our democracy. The court protects our rights, but elected officials can define the policies that the courts are weighing in on. We have to balance our communal needs with the individual rights. And civil liberties is to protect the rights of individuals, even if it means stopping the majority of the country. So this is an ongoing challenge. There's a couple of different topics here that you can look at. Crash course, one on religious freedoms, guns, and on racism. And you can help yourself to that if you like. And some of the exam notes for this chapter is know and understand the following topics. You should understand the difference between civil liberties and civil rights. That was discussed at the beginning of the chapter here, or the beginning of the lecture. You should completely understand the 14th Amendment. Please read that up on your chapter and read it in the Constitution. You should understand selective incorporation of the Bill of Rights, the right to privacy. I would read that in your chapter as well. Understand the freedom of religion in the First Amendment and the two parts of it. You should understand freedom of speech. It's the most protective right, clear and present danger, and you should understand what symbolic speech is. And you should understand the exclusionary rule, the Miranda rights, and the Patriot Act. All right, that's it for this lecture. I'll see you momentarily on civil rights.